Good afternoon, everyone, and thank you for joining us for the Medical Board of California Panel A meeting. Pursuant to SB 189, this meeting is being conducted via WebEx. If you're having difficulty hearing the audio of this meeting, it could be because the device you're connecting with has bandwidth limitations. If you do have difficulty hearing the audio of this meeting using your device, please click the ellipsis button at the bottom of the WebEx application or the audio and video menu item at the top of the WebEx application, and then select Switch Audio. You'll see an option to call in and will be provided with a telephone number, access code, and attendee ID that can be used to connect to the meeting audio via phone. Using the information provided, it will automatically disconnect your device's audio and connect your phone to the name you joined the meeting with. By using this method, if you're having audio problems with your device, this will allow you to still participate and hear the audio of the board meeting. Please see the instructions on how to connect link on the last page of the meeting agenda for step-by-step WebEx instructions, including screenshots. Thank you, Ms. Lubiano. You can now start the meeting.
Thank you, Sean. Can you hear me okay?
Yes, we can.
Oh, apologize. I have two sick office mates here with me, so I'll do my best. Thanks for hanging in there. My name is Lori Rose Lubiano, Chair of Panel A, and the first item on our agenda is the call to order and roll call. I'll turn it over to Ms. Jeremiah.
Okay. Dr. Bolat?
Present.
Dr. Hawkins?
Here.
Mr. Rue? Sean, did Mr. Rue join?
I did. Sorry, Andrea. I did not see Mr. Rue join. No.
Dr. Sai?
Here.
Mr. Watkins? Okay, absent. Ms. Lubiano?
Present. Thank you.
All right, we have a quorum.
Great. Moving to item number 2 on our agenda is the oral argument on non-adopted proposed decision for Dr. Vijaya. And I will now turn it over to Judge Aspinwall. Thank you.
Thank you, Ms. Lubiano. Can everyone hear me? Okay, thank you. The record should reflect that a quorum is present. We are on the record in the matter of the petition for penalty relief of Bangaruswamy Vijaya KUMAR. This is case number 800-2021-079957, Office of Administrative Hearings number 2022-080-430. It is February 8, 2023 at approximately 12:10 p.m. And this is the time and date set for oral argument in this matter. My name is Timothy Aspinwall. I'm the administrative law judge assigned to preside at this hearing. And we do have a quorum, but for the record, will the board members please identify themselves, starting with the chair?
Thank you. Lori Rose Lubiano.
Reedy W. Hawkins, MD, Vice Chair.
Michelle Bolat, member.
Dealing Sai, member.
Okay, and thank you. Again, let the record reflect that a quorum is present. Now, is there a Deputy Attorney General present?
Sorry about that here. Let me go ahead and elevate them to the panelist role. So you should have the Deputy Attorney General now.
Good afternoon, Your Honor. Yes, Kalev Cassiaro, Deputy Attorney General from the Office of the Attorney General, present.
Thank you. And is the petitioner present?
Dr. Kumar, are you present? I see him on the list here, but I think his mic is off. This is Albert Garcia. Can you hear me?
Yes, sir, I can hear you. I'm present.
Can you hear me? Okay, and so Dr. Kumar is present, and is Dr. Kumar represented by anyone?
Yes, Your Honor. Can you hear me? This is Albert Garcia. Can you
Yes,
hear me?
I can hear you.
Okay, well, I represent the petitioner, in this case, Dr. Kumar.
Excellent. Okay.
Mr. Garcia, you can start your video now if you'd like as well, too, now that you're in the panelist role.
How do I do that?
Little button at the bottom that says start video.
Thank
Just
you.
click it one time. I think you double clicked it and it flashed for a second.
Well,
There we go.
all right.
Thank you, Mr. Garcia.
Thank you.
Okay, so this matter has been set for hearing following the non-adoption of the proposed decision. The parties are permitted to make oral arguments within the following time limits. The petitioner may argue for 15 minutes, then respondent may argue for 15 minutes, then rebuttal arguments of 5 minutes each. Arguments will be based on the record, and no new evidence is permitted. Board members and the administrative law judge may ask questions of either party regarding the record and arguments. The petitioner, Dr. Kumar, excuse me, will be sworn in if he wishes to testify or if the board members ask questions of him. So, Mr. Garcia, are you prepared to argue?
Yes, I am, Your Honor. Thank you.
Okay, and you will have until 12:30. Please proceed.
Members of the panel, you have read the record and the administrative law judge's proposed decision. You have read the ALJ's assessment of the evidence. And you have read the ALJ conclude that, this is from the proposed decision, quote, since 2019, which is prior to the effective date of the decision in this case, petitioner Dr. Kumar has been professionally evaluated by 3 psychiatrists, none of whom found petitioner to have an alcohol use disorder or a need to be monitored. Moreover, petitioner submitted to biological testing in Texas and California for almost 3 years without a positive result. Ultimately, and I'm still quoting from the ALJ's proposed decision, ultimately, the burden is on petitioner to demonstrate that he is sufficiently rehabilitated to justify early termination of his board probation. Continuing with that conclusion of the ALJ, quote, as set forth in the factual findings, petitioner has met this burden. Petitioner has demonstrated to the board that he is safe to resume unrestricted practice as a physician and surgeon in California at this time, end quote. You have also read the remarks and observations of counsel for the people, and you will hear from him momentarily, who, as an advocate, insists that Dr. Kumar has fallen short of the mark in demonstrating his rehabilitation. Interestingly, one of the reasons advanced by counsel is that, quote, petitioner has never been evaluated for an alcohol use disorder or fitness to practice by an independent evaluator selected by the Medical Board of California, end quote, suggesting either that the independent evaluators selected by the Texas and Pennsylvania boards were not impartial, or more likely, that the evaluator selected by the Medical Board of California would render the result that counsel would prefer to hear. Well, that's not the way it works. Counsel's remarks, observations, and opinions about the evidence are obviously colored by his role as an advocate. Not so with the conclusions reached by the administrative law judge. The administrative law judge, who heard the evidence and observed the witnesses while they testified, albeit remotely, and who reached the conclusions regarding Dr. Kumar's rehabilitation and fitness to practice without restrictions, was acting as an impartial arbiter, not an advocate, an impartial arbiter. As an impartial judge, he was acting in accordance with the mission statement of the Office of Administrative Hearings. The stated mission, as an independent agency, is, quote, to provide a neutral forum for fair and independent resolution of administrative matters. So, how are you, the members of the panel, going to resolve the variance, the conflict, if you will, between the views advocated by counsel and the findings made and conclusions reached by the administrative law judge? Well, fortunately, the legislature has provided you with some guidance, more accurately, with a mandate on how to resolve the diversions between what counsel would have you believe and what the ALJ concluded after an impartial assessment of the evidence. The legislature has decreed that, quote, when considering a proposed decision, the board or panel shall give great weight to the findings of fact of the administrative law judge, end quote. That's Business and Professions Code section 2335. And when you think about it, this directive makes a lot of sense because the ALJ had the opportunity to hear the evidence firsthand and to observe, although remotely due to the pandemic, the demeanor of the witnesses, and on that basis, evaluate credibility and arrive at factual determinations based on that first-hand assessment. Now, what do the findings of the ALJ show in this case? Dr. Kumar's period of sobriety, these are all factual findings, by the way, that I'm referring to. Dr. Kumar's period of sobriety extends back to May of 2017, which is confirmed by biological testing in Texas and California since April of 2019 with no positive results, and by the 3 psychiatric evaluations conducted since 2019, none of which found an alcohol use disorder. As to those psychiatric evaluations, the Texas board ordered petitioner, by the way, Dr. Kumar reported his DUI conviction to the Texas board and the Pennsylvania board. So the Texas board ordered petitioner to undergo a fitness for duty evaluation with Michael Fuller, a psychiatrist, who found, quote, no substance use disorder, no psychiatric diagnosis, and no impairment to his fitness to practice medicine, end quote. And accordingly, Dr. Fuller made no treatment recommendations. The Pennsylvania board also referred petitioner to a psychiatrist for an evaluation. And that was with Dr. Marina Goldman. As she conducted a psychiatric evaluation of petitioner and again found, quote, no alcohol use disorder diagnosis and no substance use disorder diagnosis. And she too found, quote, no current evidence of risk of impairment in clinical duties, quote, end quote, and concluded that Dr. Kumar was fit for duty. Now, after the accusation in this case was filed, Dr. Kumar self-referred to Michael Sucher, S-U-C-H-E-R, MD, an addiction specialist, for yet another evaluation. And Dr. Sucher completed the assessment and wrote a report finding the petitioner had no alcohol use disorder, no impairment to his fitness to practice medicine, and no need for further evaluation, treatment, or monitoring. The ALJ also found the petitioner had submitted to biological testing in Texas and California for almost 3 years without a positive result. The evidence at the administrative hearing showed that Dr. Kumar has accepted responsibility for his misconduct and expressed remorse for it. He has complied with all the terms and conditions of his criminal probation and was released from probation on February 26, 2020. Dr. Kumar has performed volunteer work. I'm quoting the factual findings of the ALJ. I'm not making this up. He has performed volunteer work at the Lestonic, that's L-E-S-T as in Tom, O-N as in Nelly, N as in Nelly, A-C, Free Clinic in Orange, and the Free Clinic of Simi Valley, California. He testified that he exercises daily to support balance in his life and that he has a strong support network consisting of his wife of 30 years and professional colleagues with whom he maintains ongoing relationships. As a result of his rehabilitative efforts, Dr. Kumar has remained sober since May 2017, and he testified under oath that he has no desire to drink whatsoever. Petitioner offered several letters to support his petition from colleagues and friends, all of whom describe petitioner as a responsible and professional person, a compassionate and caring human being, and an excellent physician with sound clinical judgment. Again, quoting from the factual findings. And as someone who regrets his actions in 2017, that was when he had the DUI, and is humble and truly remorseful. None of the authors ever observed petitioner drink alcohol or exhibit signs of intoxication, and all were shocked by petitioner's lapse of judgment, which he has acknowledged, in 2017, when he drank alcohol and then drove a vehicle. The evidence also shows that Dr. Kumar has successfully completed the professionalism course, that's the ethics course, required by probation condition number 4 of this probation, including the 6 and 12-month follow-up components of the course. And he presented evidence of completion of more than 600 CME credits. Dr. Kumar has met all the criteria for rehabilitation set forth in the regulations promulgated by the board, and these are discussed at length in petitioner's written argument at pages 14 and 17. Now, these are regulations that the board itself has promulgated, establishing criteria for evaluating rehabilitation when a person has been convicted of an offense like a DUI. And they're all listed there, and I've listed it in the written argument and shown how Dr. Kumar has met every single one of the criteria listed there by the board. I note that that in the written argument submitted by the people, there's no reference to these regulations, which I think are really important because they define the way or set forth guidance as to how rehabilitation is to be determined in a case of this kind. Now, there is a tolling issue in this case. Petitioner has in fact been monitored by the board during his probation. He has submitted quarterly reports to the board throughout the period of his probation. The board likewise monitored petitioner's bodily fluid test results through the entire first course of his probation. I guess I should clarify this. It's in a written argument, but Dr. Kumar was not in California. All right? He's practicing in another state. And so there's a question as to whether his probation was told during the period of time that he was practicing out of state and not practicing in California. I should have made that clear from the start. But again, the doctor has been monitored by the board nonetheless because he has been submitting timely quarterly declarations in accordance with the conditions of probation. And the board, in fact, was monitoring all of his bodily fluid test results for the first year of his probation. So those test results were coming into California, and the board had the opportunity to evaluate them, look at them, and make sure that he was in compliance.
Mr. Garcia, 2 minutes.
Thank
2
you.
minute warning.
I'll just skip over here real carefully, quickly rather. Dr. Kumar has completed and passed the Federation of State Medical Boards expense examination because he hadn't practiced in California for 18 months. He passed that. He's been practicing in California for 40 hours per month during his time between the two clinics I just mentioned, at the two clinics. And he has been practicing in multiple states without issue since 2017. So here, even though he has not complied with condition number 11, the board accepted his petition for early termination, and it was before the board for resolution and went before the ALJ, and the ALJ proposed a decision on it. So the finding of the present condition was authorized under Business and Professions Code Section 2307, which allows a 1-year waiting period for a probation period of less than 35 months. I just want to conclude with one comment, and that is that there's a decision of the board. It's not a presidential decision, but it's case number 800-2018-043157, petition for early termination by Dr. Bernick, B as in boy, E-R-N-I-C-K, same situation. And there the board granted the early termination of probation, notwithstanding the fact that Dr. Bernick had never practiced in California during his probationary period. So there is precedent for granted, notwithstanding non-compliance with that particular condition. So I think, based on everything I've said, I think the ALJ got it right, and that I urge the board panel here to adopt the decision of the administrative law judge. Thank you very much, Your Honor.
Thank you, Mr. Garcia. And Mr. Caseru, you have 15 minutes, 12:45. Please proceed.
Thank you, Your Honor. The board was correct in not adopting the ALJ's proposed decision. A brief factual timeline, which I believe is relevant to all of the evidence in this case, is that petitioner first was convicted of a DWI in Texas in 2008. In 2017, he was arrested after a motor vehicle accident and suspected DUI in Texas. The forensic report of his blood test from that stop revealed a blood alcohol level of 0.179. In 2018, this was in Texas, he entered a no-low plea and was convicted of DWI second offense. That was in a 10-year span from his first DWI conviction. On December 13th of 2018, the board interviewed the petitioner. On March 25th of 2019, an accusation was filed based on the DWI conviction. And on July 9th of 2020, the decision and stipulated settlement and disciplinary order went into effect, placing petitioner on 35 months of probation. From that date, petitioner's probation before the California Medical Board tolled for a period of 683 days. Mind you, it was only a 35-month probation to begin with, but probation tolled for 683 days until May 23rd of 2022. And this was due to non-practice in California. Petitioner was informed of this, was aware of this, met on the 23rd of May with an enforcement analyst from the board, acknowledged meeting with them, and was given a new expected end date of the current probation for May 22nd of 2025. Our arguments are the same that we had at the hearing, which is that there are two grounds for which to deny petitioner's petition for early termination. The first is that petitioner's request lacks jurisdiction in that it's untimely. The facts and dates that I've just mentioned are undisputed by both parties, and as you heard counsel state, there was a period of non-tolling due to non-practice in California. That was a violation of Condition 11. So while the statute that counsel referred to states that, yes, 12 months must have passed or elapsed since the implementation of the stipulated settlement and decision, we would argue that the mere elapsation of time, if you just think that 12 months go by and then you can file a petition for early termination without having actually been in full compliance with probation, invalidates all of the conditions and probationary order by the board. In that this would allow anybody whose probation tolls, in this matter we have a very lengthy tolling, But they could just toll their probation with no in-state practice if they're an out-of-state practitioner, as the petitioner is, and then evade all of the other requirements due to tolling, and then file for early termination without having successfully demonstrated any compliance with the other conditions. That is our argument, that it's statutorily untimely and that petitioner's petition should be dismissed on its face. Again, if we accept that, well, all you have to show is, and the statute is clear, it says 12 months have elapsed, but I would argue that the intent behind it is that 12 months of compliance with probation is what must have elapsed, because there has to be some type of record of compliance with probationary conditions in order for the board to make any decision on whether there is any threat or harm to the public or public safety, because protection and rehabilitation are the board's reasons for the conditions of probation that have been put into place, and the monitoring that seeks to look at how has petitioner complied, and is he safe to practice? Is he a threat to the public in California? For this reason, we say petitioner's petition must be denied, because he had only been successfully compliant with his probation since May of last year, May of 2022. Now, I cannot speak to the record is what the record was as of hearing. I cannot speak to whether the petitioner has been in compliance since that date, but we still wouldn't even bet at 12 months, given that today's hearing is taking place in February. If the board does find that petitioner's petition is timely and should be considered, then the petitioner's petition should be denied due to not enough time having elapsed for the board to monitor petitioner's compliance with all of the probation conditions, and for a complete lack of evidence of rehabilitation. Now, as stated, petitioner has not been in full compliance due to tolling. He began full compliance only in May of 2022, and there simply is not enough of a probationary compliance record to review to determine whether or not he is a risk to public safety. Now, with regards to his evidence of rehabilitation, petitioner argues that he has been rehabilitated based on the evidence he has presented. But analysis of his evidence reveals that petitioner has demonstrated a pattern of consistently minimizing and misrepresenting his alcohol use and/or potential abuse. In petitioner's presentation of the events leading up to his second DWI conviction in a span of 10 years, he omits key facts such as the discovery of a half-empty bottle of whiskey under the driver's seat of his vehicle by the police. His narrative is that he had consumed alcohol prior to and during a flight from the East Coast to Texas, and then consumed additional alcohol at his home after arriving home and prior to going to sleep. His version of events does not explain how he had a blood alcohol content of 0.179 on the morning after this alleged consumption of alcohol, and why there was a partially consumed bottle of whiskey under his driver's seat. Key to these two items is that the evaluations that he cites to, all of those evaluations were prepared prior to the stipulated settlement in this matter. And a review of those evaluations, when you look at what the evaluators' materials that were relied upon, and based on his testimony at the hearing, petitioner has admitted that he did not provide a copy of the police report to the evaluators. He claims they had access to it, but that document is not reflected in the materials reviewed. In all of their evaluations, when they provide a narrative what happened, none of them state any explanation or reasons given for the bottle of partially consumed alcohol found underneath the car seat. When questioned about this in cross-examination, he stated that he did not reveal to any of these evaluators, all three of them, that the police had found a bottle of partially consumed alcohol underneath his car seat. Furthermore, he states that he participated in AA as a condition of his Texas criminal probation. When cross-examined, he could not name a single tenet or step of the AA program. He testified that his participation was more of an observer status. He relied upon the opinions of all three evaluators that he, quote, did not have an alcohol disorder, so therefore he was not required to participate in any of the steps, earn any tokens through AA. He has never admitted that he has a problem with alcohol, that he's abused alcohol. He could not provide a specific date of sobriety when questioned. He finally told the ALJ upon questioning that it was immediately after the incident, but could not provide an actual date. And he maintains that he has not had any alcohol from that date and time. and had no explanation for why in one of the evaluations, the Fuller evaluation, that it had been recorded by Dr. Fuller that petitioner had self-reported during the analysis or during the evaluation interview that he consumed alcohol 2 to 3 times a week, but each time he did so, he consumed to excess and the point of inebriation. When cross-examined about that line in the report, petitioner stated that he did not know why that was included, that he had never made any such revelation or admission to the evaluator, and that must be a mistake. It should also be noted that during the hearing, it was discovered through the documents examined by Dr. Goldman that Dr. Fuller had written a prior report to the one that petitioner has submitted. It has never been made part of the record, has never been furnished in discovery, and that in that report, he diagnosed petitioner with an alcohol binge type disorder. Petitioner admitted that that document he did not have, he did not provide it, he could not provide the ALJ with an explanation of why that had not been provided. He stated first he couldn't locate it and then it had been destroyed. I would note as an administrative point, I'm going to start referring to some transcript citations when I go over the evidence that I'm about to review. These were not provided in the brief. The summaries of the testimony were, but the transcripts had not been made available. They were not produced by OAH in time for the filing of the brief. So I will add them in as a kind of parenthetical if the board wishes to seek the transcript pages that would accompany the, again, what I had argued previously at the hearing and in the brief. So this isn't new evidence, it's just I'm providing cites because the transcript cites weren't available in the filing of the brief. And so for attending AA meetings, that would be pages 104 through 105 of the transcript, where petitioner testified he couldn't name any of the 12 steps, had not earned any tokens, and that he really did not actively participate. He just attended and observed. And again, he states that he wasn't required to do that because he wasn't found to have any alcohol disorder. For the Dr. Fuller evaluation and why that Dr. Fuller described the petitioner had reported to him a pattern of drinking to the point of intoxication, that's pages 116 through 117. In the Goldman report, the evaluation by Dr. Goldman, she refers to Dr. Russ Carter of the Texas Medical Board. He was the medical director of the Texas Physicians Health Program. And Dr. Goldman quotes in her report that Dr. Carter described petitioner as being abusive to staff and not being forthcoming with regard to his alcohol use and non-compliant with his Texas Medical Board monitoring. That's pages 108 through 112 in the transcript. When petitioner was cross-examined about this, he said he did not know why that Dr. Carter would have reported that to Dr. Goldman, and he said he hadn't really read that portion of the report, even though that is an evaluation that petitioner provided as evidence of his rehabilitation. He stated that he did not, petitioner stated he did not provide copies of the California Medical Board accusation, the police reports, nor divulged that a half-empty bottle of whiskey was found under his driver's seat to any of his evaluators. That's pages 112 of the transcript that referred to Dr. Goldman's evaluation, and page 118, which refers to the evaluations conducted by Dr. Fuller and Dr. Sucher. Furthermore, in one of his letters of recommendation, the one provided by Dr. Adams, dated October 3rd, 2022, Dr. Adams wrote that petitioner continued to attend AA meetings and was participating in regular monitoring when in fact petitioner was doing neither. Under cross-examined, petitioner admitted that he wasn't undergoing at the time of the hearing any AA meetings or monitoring, and he said he did not know why Dr. Adams would have included that in his letter of recommendation, and that he didn't really review the letter before he submitted it, even though that was solicited by the petitioner and submitted as his evidence. That's pages 105 through 106 of the transcript. He stated that he did not inform Dr. Adams of those two facts and does not know why it was included. All of these form a pattern of minimizing and misrepresenting his use and potential abuse of alcohol. The reasons these evaluations should not be considered as valid is because the petitioner withheld these key facts. The fact that a bottle of partially consumed alcohol was found underneath his car seat the day of the accident, what his actual blood alcohol content was. Petitioner has never, in any of his written materials or his oral testimony at the hearing, stated that he had a problem with alcohol. Well, if we were to believe petitioner, then what explains those admissions that, other than it's a mistake to the evaluator, what explains his blood alcohol content, not the night of his consumption, but the morning after in the empty alcohol bottle? Those are never addressed. There's no explanation given. We're just referred to the conclusions of the evaluators that, look, there's no problem here. 2 DUIs and 2 DWIs, rather, in 10 years. These omissions and evasions and the reliance on, oh, the evaluator said I don't have a problem, I didn't have to actually complete AA. That's not evidence of rehabilitation. The argument would seem from petitioner that we don't have to have evidence of that rehabilitation because no one has said it's a problem. Well, how can anyone say it's a problem when you omit key facts when you self-report these things to your evaluators?
2 minutes. 2 minutes.
Thank you. That is the evidence before you. That is testimony from the petitioner. That is testimony and evidence from the reports that he submitted. And so for the second prong, we argue that there hasn't been evidence of rehabilitation. All of these contradictions are responded to by petitioner as either mistakes or errors by the evaluators. He doesn't offer any evidence or explanation for those. And so we would argue petitioner has not taken full responsibility for his action and has not been rehabilitated with regards to potential to abuse alcohol. And as such, the board shouldn't rely on the conclusions of these evaluations due to petitioner's omissions and concealment of relevant material facts to the evaluators. In conclusion, the board should deny petitioner's petition for early termination of probation. Petitioner should continue on probation, continue to fulfill all of his required and agreed upon conditions so that the board can continue to monitor his compliance in order to determine whether or not he truly represents a significant risk to public safety.
Thank you, Mr. Kisioru. And Mr. Garcia, you have 5 minutes.
Listening to counsel's remarks, I'm starting to wonder which case was it that the ALJ heard, and which case was it that counsel heard or participated in. It kind of reminds me, because I'm a football fan, when a foul is called on the field, and then there's a replay, and you see the replay, and you're sitting there watching it on TV, and then the ref comes in and calls it completely inconsistent with what you see on TV. And I turn to my son and I say, I wonder which game the ref was watching. Well, I wonder which case the ALJ heard, in which case counsel participated in, because every one of the details that counsel just went through right now, these inconsistencies that he calls them, with giving you transcript pages, citations, all of that came out during the hearing. And the administrative law judge heard that evidence. He heard all that evidence. He heard what the testimony was at cross-examination when counsel was trying to establish the inconsistency. The ALJ was sitting there listening to it, evaluating all that evidence. And yet, the ALJ came to the conclusion, after hearing all of the evidence, including the evidence at cross-examination and the bottle that was never mentioned and other details that counsel has referred to, the ALJ took those matters into consideration and still found the petitioner established his rehabilitation and fitness to practice medicine without restriction in the state of California by clear and convincing evidence. Now, counsel had the opportunity to make all these arguments that he just made before the panel today at the conclusion of the hearing, pointing all these inconsistencies out to the ALJ. And the ALJ again heard counsel's remarks and evaluated and assessed the evidence and came to his conclusion. And again, I refer to the legislature's decree here that says, when considering a proposed decision, the board or panel shall give great weight to the findings of fact of the administrative law judge, not the remarks of counsel for the people in this case. On the tolling issue, I've cited a case to you. It's not a presidential case, but it certainly offers you guidance. You know, it's Stephen Bernick, B-E-R-N-I-C-K. And in that case, it was a petition for early termination of probation. The petitioner there never practiced in California even for one day. Dr. Kumar has at least practiced in California for a period of time, not, completely in compliance with condition number 11, but at least he's practiced in California for some period of time. The case I cited, 800-2018 043157. Petitioner there never practiced in California for 1 day. And at the very conclusion, the board says, although his probation has been told and he has not been able to fully comply with condition 11 of his probation, petitioner has practiced without incident out of state while on probation, and his rehabilitation efforts are compelling, and the petition was granted. Well, same thing with Dr. Kumar. He's practiced out of state without incident during his entire probationary period. He submitted the quarterly reports, and the test results from his bodily fluid testing came into California, so he was being monitored by California. So this statement here by counsel that there's a lack of evidence of rehabilitation, that's just contrary to the record. You have those three.
1 minute, Mr. Garcia. 1 minute.
Thank you. So he's concerned about the protection of the public here in California. Well, you have 3 psychiatrists, 3 who evaluated him, and each one came with the conclusion that the doctor does not pose a risk of harm to the public. He can practice without restrictions or without any kind of monitoring. So the evidence is there on the record, and the ALJ's decision, I think, is supported by ample evidence, clear, convincing evidence, that should be adopted by the board. Thank you very much.
Thank you, Mr. Garcia. And Mr. Kesioru, you have 5 minutes until 12:55.
Thank you, Your Honor. First, and I did not object to this when counsel was making his argument. I didn't want to confuse the timelines, but I believe this case site that he's providing, and forgive me if I'm wrong, I'll withdraw the objection, but I don't believe that was part of petitioner's brief. I don't see that cited there. The hearing is limited to the evidence on the record. Again, if I'm wrong about that, I tried to find it, but I would withdraw the objection. But otherwise, I object to the discussion and admission of anything that wasn't previously concluded in his brief, and certainly that was not argued by petitioner during the hearing proper. Going to the actual rebuttal against petitioner's points, the ALJ proposed decision does not address a single one of the arguments that I made today, and my arguments were identical at the hearing. They are not addressed and dismissed. They are not taken apart. They're not compared with testimony from the petitioner. They are simply not present in the proposed decision whatsoever. So to say that these findings of fact have great weight, I would argue that there isn't any argument about the factual issues that I presented. These are not my opinions. These are based on the actual testimony of petitioner during the hearing. Not a single one of these arguments was addressed in the proposed decision. They were not resolved. The discrepancies, the inaccuracies, the omissions, they're not referred to at all. The record is completely silent from the ALJ on that in their proposed decision, and that's why I argue that it's wrong. Regarding any practice in California, again, I'd refer you to the transcript. The petitioner admitted that that volunteer position was found for him by the board enforcement analyst so he could remain in compliance with California practice. The proposed decision makes it sound like the petitioner has engaged in this volunteer work out of the goodness of his heart. He didn't locate it. It was found for him by the board monitor. And again, everything I presented are the arguments I presented at the hearing. None of them have been addressed. The tolling argument wasn't addressed either. It was just stated, again, unequivocally, everyone has admitted that his probation has tolled. He had only been in compliance for beginning May of 2022. That is not in dispute. The ALJ did not address any of my tolling arguments one way or the other. They were ignored in the proposed decision. But none of my arguments are novel today. They're all in the transcript. None of them have been addressed, and that's why I make them to the board. I think they're key in making a decision in this matter.
Anything further?
Not from here.
Thank you. Okay, arguments have been made and heard. There's been an objection, which I will rule on now. The objection is to Mr. Garcia's reference to a case citation in the course of argument, that citation having not been cited in written argument. I'm going to overrule that objection. for the reason that in many cases, no written argument is submitted, but there's oral argument and reference to case citations, legal authority is permissible under those circumstances as it is here. So while it is, so without further comment, I'll overrule that objection. Now I want to give the board members an opportunity to ask questions of counsel, and if they wish, of Dr. Kumar. If there are questions of Dr. Kumar, I will swear him in. Ms. Lubiano, do you have questions of either counsel?
No questions at this time, Your Honor.
Dr. Hawkins, do you have questions of either counsel or Dr. Kumar?
Questions for both.
Okay, please.
So for counsel, do we know whether Dr. Kumar is being followed on probation currently since May of 2022 in California?
My understanding is that he's still, well, no, my understanding is he continued to be on probation until that's a good question. Since the decision was not adopted, the only thing I can say that as far as I know, as far as I think or believe, that he's still on probation and he's still being monitored. That's my position, but Dr. Kumar would be a better position to fill us in on that.
Will he be sworn in, Judge?
Dr. Kumar, if you'll raise your right hand, I'll swear you in. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. And so for the record, please state your first and last name.
Bangaruswamy Vijaya Kumar is my name.
Okay. And so please go ahead with your questions, Dr. Hawkins.
Thank you very much. So the record suggests that biological fluid testings between July 2020 and July 2021 actually occurred in California. Dr. Kumar, does that mean that you came to California, submitted a specimen timely with negative fluid tests in California?
It was arranged by the California Medical Board, where I check in with them every day through an app, and depending on what the app says, if I need to go do a blood test or a urine test, I have to do it on the same day, which I did throughout the year 24 times. That includes about 7 or 8 blood tests. So I had, so the whole results went to California Medical Board and was monitored by the California Medical Board and was administered by the California Medical Board. Yes, sir.
So were the tests performed in California or some other state?
Wherever I am. So they were allowed to do, they had laboratories that they let me use. So I was in Houston, I used them. When I was in California visiting them, I used them. I couldn't do that out of country. That's
Okay.
okay.
Are you
Can hear
currently
me, sir?
practicing in California?
Well,
Being a monitor?
I do come there because because after 18 months, it says I violate the non-practice clause. So I have to take the specs exam, and I volunteer in the Westmont Free Clinic and Simi Valley Free Clinic about 40 hours to satisfy the conditions. So they let me come there, and I do primary care mostly, even though I'm a neurologist. I do some neurologic cases. I do some follow-ups. I was not allowed to do any televisits, but I do come there every month since May, and I'm scheduled to come this month.
So when you do those tests, are your charts monitored, or are reports submitted to a probation officer with the records attesting to you providing care to these patients when you do that work in California?
Yes, sir. I do have a practice monitor. I mean, it's not a practice monitor. My monitor, her name is Alta Mariano. She visits with me quarterly, mostly at the place of my work. So she asks me the dates I'll be on, and she'll make arrangements to meet with me once every quarter. She's done 3 times.
Has she ever reviewed any of the records from California?
When I was working with the patient, one time she did. She opened the chart and then she did review the chart. Not every time, but she did.
And that was submitted to California?
I'm not sure what she did.
Okay.
What she does, because my settlement agreements were mainly educational, the first year of bodily fluids and ethics course. So she is well aware of that, and she also makes sure that I don't have any nurse practitioners or anybody working under me. That's one of the requirements. So she monitors those. I think the conditions I signed up on the settlement, she monitors. I know that for sure.
Okay. So my final question is, do you have any comments about the allegations about your commitment to alcohol use, commitment to AA, and or things along those lines brought into question by board counsel?
Thank you for asking me that. Thank you for asking me that. And I also want to thank the Medical Board of California for allowing me to participate in this hearing. I'm pretty ashamed myself to be in this situation today. I also want to express my sincere apologies for my deeply flawed lack of judgment to drive after drinking, which led to a conviction, which is a crime and which is the basis of settlement with the board. I want to express my deep regret and deep remorse for recklessness and dangerous acts, and I acknowledge the seriousness of the regretful conduct which could have caused potential harm to myself, others, property, and it's a good concern of the board that it could cause patient harm because of my lack of judgment at that time. There are no excuses for my conduct. I deserve to be disciplined by the board. And through the next 6 years, through the ethics course, other difficulties in obtaining jobs and multiple other reasons, going through the rehab, which gave me much insight into my problems, vulnerabilities, boundaries, and I'm always on the lookout for the slippery slope, to not to be in any situation of ethics violation or any future violations. I completely stopped drinking on May of 2017 when I had to wear an interlocking device to drive for the next 26 months before the judge let me take it out. So throughout that period, I was monitored. Every time I took the vehicle out and it let me go. And following that, for the next 3 years, I was monitored by Texas Medical, initially by PHP. They wanted me to be monitored for 2 years. But in Texas, I had a choice of asking my case to be transferred to the Texas Medical Board for review. And the Texas Medical Board reviewed, and they investigated. They monitored again for next 6 months or so with 25 tests. And the meeting with the Texas Medical Board, they concluded that I did not have any violations of Medical Practice Act, and they didn't need me to do any monitoring and safe to practice medicine. Same thing as Mr. Garcia just said. The Pennsylvania board did the same thing. And even here, I'm trying to be very compliant with all the requirements of my settlement, which was the first year of monitoring 24 tests with at least 7 or 8 PET tests, which monitors long-term compliance. And I was monitored at least by three psychiatrists who did not think I had an alcohol use disorder. Also, I do apologize that I misused alcohol. That led to all these problems. And as Mr. Kello Kasarov said, the Texas PHP director, he also did not think I had a alcohol use disorder in the same paragraph as he quoted. And I've been tested multiple times, and I have educational requirements, and I've done the ethics requirements, and I've done over 600 CME hours. I'm a board certified neurologist and I have multiple subspecialties. And since the acquisition, I have recertified in neurophysiology, neuromuscular disease, electrodiagnostic medicine, sleep medicine. And initially, the American Board of Psychiatry and Neurology, they wanted to take my take my diplomas away. But after I gave all the explanation, they did not invalidate my licenses. They also let me qualify for the newest American Board of Neurology and Psychiatry subspecialty in neurocritical care, which I passed last year. So I've done all those educational requirements, and I'm also doing the requirements of practice in California as much as I could. So I through all these actions, I've demonstrated that I'm no risk to the public, first thing, and I have been tested negative so many times, and I think I proved to the board that I am rehabilitated and safe to practice unrestricted again. Essentially, respectfully request the board to adopt whatever the AOJ proposed.
I have no other questions.
And do you have any questions of the Deputy Attorney General, Mr. Hawkins, Dr. Hawkins?
I do not.
Okay. Dr. Bullitt, do you have questions of either counsel or of Dr. Kumar?
Not at this time, Your Honor.
Okay. And Dr. Sai, do you have questions of either counsel or Dr. Kumar?
I do not, Your Honor.
Okay, then and I will circle back to Ms. Lubiano. Any further follow-up questions?
No more from me, Your Honor. Thank you.
Okay. Then the matter is submitted. The record is closed and we are off the record, and we will move into a closed session. Thank you
very
all.
much, Your Honor. Thank you, members of the panel. Thank you very much.
Thank you, members of the panel.
Thank you, Judge Asamal. Ms. Lubiano now, so we will go ahead and keep this meeting open for the public. We'll put up a closed session slide, and so you guys can return at the end of the closed session for adjournment. You should have a invite, all the panel members and Judge Aspinwall, a invite with the time of 12:45 on it for a closed session. If you can, go ahead and leave this meeting, I'll keep it open, and leave this meeting, join up over there, and we will continue with the closed session over there.
Thank you.
Thank you, Sean.